Did you know that the key to an effective cross-examination in the family law courtroom does not involve you screaming at the top of your lungs and slamming your fist down on the desk in front of you? Did you know that there is a formula taught by law professors that shows you exactly how to do an effective cross-examination while, get this, being nice and respectful and calm? It's true. If you want to know more about cross-examination in the family law courtroom and the 3 C's of cross-examination, you're in the right place. Watch this video now. If you haven't already subscribed to Command the Courtroom's YouTube channel, hit the button now. Don't forget to ring the notification bell. That way you get notified each time I release a new video. And if at the end of this video you like what I had to say, feel free to give it a thumbs up. Also, don't forget to check out the hundreds of other videos on the Command the Courtroom channel. I guarantee there's something out there that's going to help you in your family law case. My name is Wendy Hernandez, and I am a Phoenix, Arizona family law attorney. I'm also the creator of Command the Courtroom. My passion is creating these videos and educating people just like you about the family law courtroom and process so you can walk into that courtroom not feeling terrified, not feeling overwhelmed, but instead feeling confident and competent and knowing that you did the best job you could to get a result that's in the best interest of your family. If someone were to ask me what my favorite part of a trial is, without a doubt, I'd say it's cross-examination. There is an art to cross-examination. In fact, there's a very famous book called The Art of Cross-Examination, and I'll paste the link in the description below. But cross-examination really isn't that difficult once you get the hang of it, and there's actually a formula. And if you follow the formula, then you'll do a great cross-examination. And we're going to talk about the formula in the second half of this video. But first, I want to share with you some of the prerequisites to the formula, some of the important things that you need to understand before you get to the formula. So the first thing you need to know is that in the family law courtroom or in any courtroom, credibility of the witnesses is king. That's one of my favorite phrases that I like to say. Credibility is king. And what that means is in making decisions, your trier of fact, whether it's a judge or a jury, is going to be looking at the credibility of all the witnesses. The judge is going to look at whether a judge can believe a witness or not, and how much weight to give a particular witness's testimony. So in making these decisions about credibility, there's different things that a judge or a jury, if you have a jury deciding your case, will look at. So I'm just going to list off a few of the factors that a judge or jury might look at in making decisions about a witness's credibility. The trier of fact might be looking at the witness's mannerisms while testifying. Is the witness nervous? Are they shifting in their seat? Are they fidgeting? Are they sweating? Are they making contact or avoiding eye contact? Are they giving dirty looks to somebody? What are their responses like? Are they rude? Are they hostile? Are they disrespectful? Is the witness avoiding questions? What about the witness's ability to recall details? Does the witness have a good ability to remember things, or does the witness not remember a lot of things? Is the witness argumentative? Can the witness recount specific facts or details about a situation? There's a lot more, I'm sure, that I'm not listing here, but these are just a handful of the things that a judge or a jury is going to look at in deciding whether a witness is credible. So as you get set to head into the courtroom, you have to keep these in mind and check yourself, because know that you're going to be subjected to cross-examination and you want to come off as a credible witness. So don't be rude, don't be disrespectful, don't be hostile, answer calmly, know your case, don't be evasive. And also know that when you're cross-examining, you're wanting to call into question the opposing party's credibility and the credibility of their witnesses. So as you think about cross-examination in your case, keep in mind that credibility is king, and in the courtroom, you should be on your best behavior. Prerequisite number 2, as you go into cross-examination, is understanding that you can do a great cross-examination and not be rude and not be disrespectful and not be loud and not bang on tables and not scream. Like, you don't have to do these things in the courtroom. You can be sweet as pie. You can be quiet. You can be kind. You can be nice and still pack a powerful punch. A lot of people watch movies, myself included. I love watching movies, especially courtroom dramas. And we see the scenes from like A Few Good Men where Jack Nicholson is being cross-examined at the end and he just blows up and it's very tense. And there may be situations during cross-examination where it gets very tense, but it's rare, at least in my experience, where a courtroom erupts with one party screaming and just like having a complete fit. That's usually not how cross-examination works. But in that movie, A Few Good Men, remember, if any of you ever saw it, it's a great movie, one of my favorites of all time, with Tom Cruise and Kevin Bacon and Jack Nicholson. Nicholson admits to a crime, but his credibility is destroyed ultimately because he becomes so hostile. So although that's a good movie and something good to learn from, know that real life is not like the movies. And you don't have to scream to give a good cross-examination or to present a good cross-examination to the court. Okay, so the third prerequisite point that I want to talk about before we delve into the formula is this. You have to have a good command of all of the prior statements that the opposing party has made during the pendency of your case and maybe even before this particular leg of the case began. You have to know all of the statements from past hearings, from depositions, from written interrogatories, from statements to the police, to emails, to texts. You have to know what the other party said. You have to study those notes. You have to have them committed to memory. You have to have them indexed as you go into the courtroom so you can very quickly turn to them. Because the art of cross-examination involves showing that the other side has made inconsistent statements. One thing that my grandmother used to tell us growing up was, if you're going to be a liar, you better have a really good memory, because you're going to have to remember all the lies that you've told in the past. And the thing is that it's really difficult if you've told all kinds of inconsistent stories. And I find that when a person has given more than one story, it's usually pretty easy to discredit them during cross-examination. But you have to remember and have a record and keep notes of and be able to turn to those prior inconsistent statements once you get into the courtroom. So before we delve into the formula of cross-examination called the 3 C's, that's what my law professors used to call it, I want you to comment below and tell me whether there are prior statements that exist in your case that might be fertile ground for cross-examination in your case. Recordings from prior hearings, like temporary orders hearings or order protection hearings, or even past court hearings. Are there transcripts? Are there deposition transcripts? Are there written statements by your ex somewhere? Are there voicemail recordings? Are there text messages that might be helpful during cross-examination? Or what about emails? What about responses to interrogatory requests, or responses to requests for production, or responses to requests for admissions? There are probably more that I'm not naming here, but all of these are possibilities when you're looking for statements that might possibly be inconsistent with the statements that your ex or their witnesses are going to give at trial. So comment below and tell me what you have or what you can think of as far as statements that might help you as you head into cross-examination. So once you're done watching this video, don't forget to check out this video on lying in court for more information on the same topic, but expressed in a different way. This video is from a couple of years ago. All right, so let's get to what you've been waiting for, the formula to discredit your ex during cross-examination, to show that they're lying, to show that they have inconsistent statements, to show that the judge can't rely on anything that they're saying. Step number 1, the first C of cross-examination is to commit the person testifying to the prior testimony at trial. Say there was a domestic violence dispute between two parties, and during direct examination, the wife testified that the husband had hit her with a huge picture frame and shattered the glass all over the room. So, in order to commit the wife to that testimony, you would ask her during cross examination, Mrs. So and so, you just testified during direct examination that your husband grabbed a picture frame during the dispute between the two of you, hit you over the head with it, and shattered the frame and the glass everywhere. Isn't that correct? And then, so her answer would be yes, if that's what she just testified to, or it would be no, which would be very confusing for everybody, especially if she just testified to that, or it would be possibly, I don't remember. And if you have a court reporter who has the ability to read the testimony back, that would be great if the witness testifies and says, I don't remember. If you don't have a court reporter and it's only being audio recorded, that may be a little problematic. But chances are that the witness during cross-examination is either going to say, yes, I just testified to that during direct, or no, I didn't. Let's move on to the second C, which would be to credit the statement that you want to confront the witness with. And I know this is a little confusing, but the first step is commit. The second step is to credit the statement. And the third step is to confront, which we'll get to in a minute. So in the example that I just gave, wife testified during her direct examination that the husband shattered a huge picture frame over her head. But there was police who responded to that incident and actually took a police report, and they actually took statements from each of the parties. So if you've done your job, number one, you've gotten a copy of the police report, and number two, you are very familiar with every detail of that police report. And because you are very familiar with every detail of that police report, you know that nowhere in the report does it state that the wife told the police that the husband had taken that picture frame, hit her with it, and then shattered it to the ground. Nowhere did the wife say that to the police. So this is where you credit the prior statement that she made to the police by doing something like this. Mrs. So-and-so, at the time this incident occurred, you called the police, isn't that correct? And she would say yes. And the police came to the house within 30 minutes of this incident occurring. Isn't that correct? Yes. And you talked to the police about what just had happened. Is that right? Yes. And when you were talking to the police, that event was fresh in your mind. Isn't that correct? Yes. It had just happened, correct? Yes. And you included each and every important detail to the police when you talked to them that day. Isn't that right, Mrs. So-and-so? Yes. You didn't leave anything out. Is that right? No, I didn't leave anything out. Okay. So that is crediting the prior statement and really building it up, because then you're going to deliver your punch next. After this witness has said, yes, I called the police. I told them everything. I didn't omit anything. And it just happened. So this is where you're going to confront the witness with the inconsistency. All right, so let's talk about the third and final step, which is confronting the witness with the prior inconsistent statement. So we just talked about how you're going to credit or build up that prior statement. In this case, it's the police report. So you've got wife to commit that she talked to the police, she gave them all the important information, she didn't omit anything. And you know from reviewing that police report that it doesn't state anywhere in the police report that husband took a big picture frame, hit her over the head with it, and shattered it to the ground. So this is where you state, Mrs. So-and-so, you talked to the police that night and you didn't tell them that night that husband hit you over the head with the picture frame, broke the glass, and shattered it to the ground. Is that correct? And then she's going to say either no, she didn't tell them, which would be great for you because that's inconsistent with what she just testified to in the courtroom. Or she's going to say, yes, I told them that, at which point you're going to say, okay, I'm showing you Exhibit A. That's the police report. I want you to take a look at the police report. You've reviewed this police report before, correct? And nowhere in this police report does it state what you're telling the court here today. So you impeach her that way. And if she says, I don't remember what the police report says, then again, that's another opportunity for you to present her with the police report and say, here's the police report. You've read it, you've reviewed it. And if you haven't, then do it quickly if you have the time for her to do it quickly, and ask her to point out where it says that she told the police what she's saying happened in the courtroom. So hopefully that makes sense. I know it can be a little confusing at first and it can be a little overwhelming, but I promise you that if you practice it, it really is easy. It can become second nature. It's become second nature to me. You just have to remember the 3 C's of cross-examination. So the first one is committing the witness that you're cross-examining to the testimony that they just gave in the courtroom. The second step is first going through in your head and thinking about the prior statement that you want to impeach them with, whether it's an email or a text or a police report or a transcript, finding that and building up that statement saying, you sent me an email on such and such date. It came from your email address. And it's when we were talking about having the children interviewed. So you're crediting the statement that's inconsistent with the courtroom testimony. And then finally, you're confronting them with the statement, the prior statement, and the fact that it's inconsistent with the testimony that they're giving in the courtroom. Commit, credit, confront. Commit, credit, confront. And I would encourage you, as you prepare to go into the courtroom and cross-examine, write this out for each piece of evidence that you think that your ex is going to testify inconsistently about. And that brings me to my final point, which is you can prepare for cross-examination in advance. I have lawyer friends who say, hey, I don't prepare cross-examinations in advance because I don't know what the witness is going to say in the courtroom. And I always disagree with that. It's my thought that if you've done your homework, you've prepared your case, you know exactly what your ex is going to testify about. You've uncovered that during disclosure and discovery. You know what their theory is, you know what their strategy is, and you can prepare their cross-examination in advance. I prepare all of my cross-examinations in advance, and I think that's why I always have good results with cross-examination, because I'm prepared. I know what the statements are. I can access them quickly, and you can do the same. All right, so that covers cross-examination. I have faith. I know that you can do it. There are tons of other videos on this YouTube channel that will help you in the same way that this video does as far as when you get into the courtroom. Also, before you get into the courtroom, especially on a custody case, you have to be familiar with those best interest factors that the court's going to be looking at and making decisions about custody of your child. If you don't know the best interest factors in your jurisdiction, you need to. So don't forget to sign up for that best interest checklist. It's a free checklist that I developed a few years ago. And in it, I go through almost every conceivable best interest factor that exists in the United States. And you can look at them and see what applies in your case. And you have to hit on them once you get into the courtroom. If you like this video, give it a thumbs up, hit the subscribe button, ring the notification bell, check out the other videos I have, especially this one on what you should be doing during your family law trials. Until next time, don't give up, don't lose faith, keep doing your homework. You can do it, you got this, keep on trucking, get out there and command the courtroom.